Verdicts can be awarded for either party, and there can be instances where a jury has to determine the fault and negligence of each party in a case before awarding a verdict, correct?
Yes, there are a number of different circumstances where the jury may be asked to apportion fault. So you have a case where we sue a defendant for whatever reason, and the defendant makes a claim that my client is also negligent. Okay, contributorily negligent. So a good example for that would be like a premise liability is the technical term, but a fall down case. You're somewhere and there's something wrong with the walkway, the stairs, the lighting that's too dark. It's whatever the situation is. If somebody falls and they get hurt, you're almost always going to have in that kind of case the defense saying, "Well, I mean, they're not going to admit necessarily that they were negligent, but they're going to make a claim that the plaintiff was negligent, wasn't paying attention, wasn't watching where they were going, walking too fast, walking too slow, whatever their claim is." So, and in a case like that, the jury would be asked the question, was the defendant, okay, negligent? Basically, little different question, but was the defendant negligent? And then a few questions later, the question they would also be asked to answer is, was the plaintiff negligent? And then if they find that the plaintiff was also negligent, then they have to assign percentages. Out of 100%, what percentage the defendant was negligent and what percentage the plaintiff was negligent. If it's less than 50% on the part of the plaintiff, then the amount of the verdict gets reduced by that percentage. So let's say that the jury comes back and says, yes, defendant was negligent and that was the cause of the plaintiff's injuries. But then the jury also finds, well, the plaintiff was also kind of careless. So if the jury finds that the defendant was 80% responsible, the plaintiff was 20% responsible, and awards $1 million, that $1 million gets reduced by the 20%. If the jury would come back and say both parties were negligent, okay, but the plaintiff was more than 50%, say the plaintiff was 60-70% negligent and the defendant was 40-30%, then there's no recovery.